Esteemed professors, organizers, dear all, it's quite an honor and a pleasure for me to be here today. I'm really grateful to be part of this project. Considering that this conference is intended to present the preliminary results of our project, I will try to summarize it in the available time. We use the structure of the questionnaire in order to be followed more easily. So the first question, how are EU legal acts incorporated into Romanian law? The answer to these questions require a systematic approach of 3 articles of the Romanian Constitution. Article 11, International Law and National Law, Article 20, International Treaties on Human Rights, and Article 148, Integration into European Union. This article was introduced in our Constitution in 2003 when the Constitution was amended in order to prepare the accession to the European Union. The following conclusions arise from these 3 texts. Treaties ratified by the Parliament are part of a national law. Human rights treaties to which Romania is a party constitute a separate category because they form part of the constitutional bloc with the constitutional interpretative value and priority for application in the event of inconsistency of national law, as the constitutional national law contain more favorable provisions. And, more important for our topic, the founding treaties of the European Union, including the Charter of Fundamental Rights of the European Union, have priority in the case of conflict with provisions of domestic laws. The Constitutional Court stated in this regard that they have a supra-legislative but infra-constitutional positions, these treaties of European Union. So according to the Article 100 of the Romanian Constitution, as concerned the European Union Acts, we distinguish between the primary law and the secondary law. This regulation of Article 148 of the Constitution concerning the priority of the founding treaties of the European Union as well as the other binding community regulations over the contrary provisions of the national laws raise the question, what does it mean, national law? This concept of national law or internal law refers, according to the Constitutional Court jurisprudence, to all the legal system, but not to the Constitution, because the Constitution is the supreme law in Romania. You have here the most important paragraph in this regard, from the first decision of the Constitutional Court in this regard, Decision 148 for 2003 on the initiative for the revision of the Constitution. But this conclusion of the Constitutional Court of Romania has remained constant over time, being reiterated in more recent decisions, even in that one which raises tensions between Constitutional Court of Romania and European Court of Justice, and after that, the RS case. A specific dimension of incorporation is the use of European Union acts within the constitutional review. According to an established case law of the Romanian Constitutional Court, the use of a norm of European law within the framework of constitutional review as a norm interposed to that of reference, and the norm of the reference is Constitution, implies a cumulative conditionality. This rule must be sufficiently clear, precise, and unequivocal by itself. The norm must be limited to a certain level of constitutional relevance so that its normative content support the possible violation of the Constitution by the national law. The only direct norm of reference within the constitutional review being, of course, the Constitution. I emphasize in our workshop, if remember, the way in which the Constitutional Court applied this kind of reasoning in common case when Romanian Constitutional Court sent a preliminary question to the European Court of Justice. In that case, this European norm interposed to those of reference of the Constitution, Article 16 of the Constitution, was the directive of free movement. In fact, it was the notion, the word spouse in that directive. What does it mean, spouse? That one is what the norm interposed, and that's why Constitutional Court found that directive was relevant in the Constitutional Review and sent a preliminary question to the European Court of Justice. The second question, what is the approach of the Member States when the additional powers are transferred compared to those conferred at the time of accession? Does it require formal legislation? Yes, it requires formal legislation according to Article 11 of our Constitution, because in this case is necessary a law of ratification of the treaties amending the founding treaties of the European Union. In this framework is possible also the constitutional review of that treaties, if this kind of constitutional review is requested, because it is not a constitutional review ex officio. The ratification of a treaty containing provisions in violation of the Constitution can only be signed after the revision of the Constitution. The third question concerning the legal procedure at member state level, at the entry into force of the Constitutional Treaty and the Lisbon Treaty. As concerns Romania, is the case only the Lisbon Treaty, because Romania became member of the European Union in 2007. So we checked the procedure and the parliamentary debates at that time, and we found that the ratification of the Treaty of Lisbon was carried out in an emergency parliamentary procedure. No constitutional issues were raised, no limits related to the national or constitutional identity were opposed. It was mostly a celebration and not really debates at this time in the discussions. Maybe it was mentioned by the representative of the party Romania Mare that we are in Europe, we don't have to enter in Europe. And also it was interesting because in that moment one of the parliamentarians raised the issue of the new identity of the European Union, but without other explanations. The fourth question, on which issues has the National Constitutional Court refused to intervene in order to protect national law and competence, and on what grounds? We have not identified situations that can be qualified as like this, as a refusal. Maybe in this context we can discuss about the distinction made by the Constitutional Court of Romania between its competence and that of the courts of law when the issue of the interpretation and application of European Union law is raised in terms of the same Article 148 of the Constitution, because as a rule the Constitutional Court stated that it falls within the competence of the courts of law to assess the priority of applying the European law. And this is an issue of applying the law in concrete disputes and not one of constitutionality. But there are also few cases, and we mentioned them in our material, that in which Constitutional Court of Romania found the unconstitutionality of national legislation contrary to the obligation of national authorities in the context of EU accession. I gave here just one example. When considering that the Parliament had abrogated the domestic provisions allowing for an appeal against a decision breaching the European Union law, the Constitutional Court of Romania held the unconstitutionality of this provision. And in this context, it was invoked the principle of loyal cooperation enshrined in Article 4 of the European Treaty. Question 5. On which issues has the National Constitutional Court acted in defense of national law and competence, and how? We think that the very way in which Constitutional Court interprets the Article 148 of the Constitution, the integration clause, gives expression to this concept of supremacy of the Constitution and the protection of this supremacy, including in relation with the European Union. I mentioned in the previous answer, question 1, that starting with the first decision in 2003 and until now, in various tones, more cautious or more or less friendly, the court expressed this idea, which has remained a consistent aspect of its case law. Over time, this idea was developed with reference to the concept of constitutional identity, which the Constitutional Court identified it enshrined in Article 11, paragraph 3, in conjunction with Article 152 of the Constitution. In fact, it's about the eternity clause, because the Romanian Constitution provides an express eternity clause in Article 152, the limits of the revision of the Constitution. It is about the national unitary state, a republican form of government, independence of the justice, Romanian language, all of these values which cannot be changed even with the revision of the Constitution. Also, the Constitutional Court stated in some cases, in order to protect the supremacy of the Constitution and the jurisdiction of the Constitutional Court, in fact, in other decision on the initiative of the revision of the Constitution, when it was tried to change the wording of the Article 148 of the Constitution, but the court found the unconstitutionality of that revision. Another example, the margin of appreciation of the legislator in various matters related to the powers of European Union, and the integration provision covered the same Article 100 of the Constitution. For example, the retirement of the magistrates. The Constitutional Court stated that it falls within the exclusive jurisdiction of the member states. The status of the parliamentarians or judicial, more recently in 2021, the judicial organization, because the Constitutional Court noted that the way of organizing the national justice system is part of the constitutional identity of the Romanian state. I have to mention that this idea, this limit, is not contained in the eternity clause, so it's a different conclusion. It is added to that core identity. The next question, if has the interpretation of Article 2 of the European Treaty be reflected in the practice of the national constitutional courts and Supreme Courts? Because we have in the Constitution an express provision concerning the same value, the rule of law, the Constitutional Court of Romania used this article of the Constitution when comes about constitutional review. Also, this article is interpreted in correlation with Convention of Human Rights, correlated with the ruling of the Venice Commission, for example. As concerned with provisions of Article 2 of the Treaty of European Union, they are invoked recently by the Romanian courts, not only by the Constitutional Court of Romania, but also by the other courts, in preliminary reference in that case, in the case of the ordinary courts, in cases that analyze the regulation that ordered the establishment and then the dismantle of the section for the investigation of offenses committed within the judiciary, in which it was raised the issue regarding the establishment and the effects of the act adopted within the cooperation and verification mechanism imposed on Romania at the time of accession of European Union. And here I don't have so much time, but I try to put somehow in the mirror the conclusion of European Court of Justice on Article 2 of the treaty and the conclusion of the Constitutional Court of Romania concerning the same value, rule of law, but with reference of the Romanian Constitution. And the main question from the perspective of the title of my presentation, the constitutional identity. Has the interpretation of Article 4 of the Treaty of European Union been reflected in practice of national constitutional court and Supreme Courts, and on what grounds did the court base its decisions? First, we tried to analyze some specialized literature concerning this idea, and we found different concepts and different ideas on this topic. We found the concept like constitutional identity, the identity of the constitution, national identity, and also in the recent case law of European Court of Justice, we found the idea of the own identity of the European Union, which is like a limit for the national identities of the states. It's a case well known, I think, where the European Court of Justice stated that the values contained in Article 2 of the European Treaty have been identified and are shared by the member state. They define the very identity of the European Union as a common legal order. We think that this judgment established a counter limit somehow for the affirmation of the distinct national identities of the member states. Also, from the specialized literature, we found different opinions on the idea of the constitutional identity, constitutional identity as a subjective concept. Another opinion, the idea that the identity of the Constitution may differ from the jurisdiction to jurisdiction, and this applicability of constitutional provisions may be subject to the jurisdiction of the Constitutional Court or higher courts. Another opinion, more nuanced, finding in essence that the constitutional identity is a meta-legal bug and subject concept, is more than the identity of the Constitution, namely a set of norms that define the constitutional order at the given moment. As concerned the case law of the Constitutional Court of Romania, we found also the concept of constitutional identity and national identity in various contexts. Since 2019, the idea and the concept of constitutional identity was mentioned without further explanations. And I quoted here a judge of the Constitutional Court, which showed in a conference at the Constitutional Court on constitutional identity, also in 2019, that the Constitutional Court has not exploited the concept of national constitutional identity to its fullest so far at that moment in 2019, because the fact that the court was keen on proving that European law, the values and the principles enshrined in the European legal order, are unconditionally accepted. Also in the same conference, other judges of the court found that this constitutional identity, the meaning of the constitutional identity is expressed in the case law of Constitutional Court of that moment. The meaning is in the sense of the protection shield of the supremacy of the Constitution, which can be activated in the event the core of the constitutional identity would be affected. But at that moment, Constitutional Court of Romania didn't mention which is this core. Later, till that moment, the Constitutional Court held, for example, member states maintain powers that are inherent in order to preserve their constitutional identity. All that those previously mentioned have a constitutional limit, expressed in what the court qualified as national constitutional identity. The lawmaking process in this matter falls within the margin of appreciation in compliance with the constitutional limits regarding constitutional identity, in conjunction with national sovereignty, the relation between constitutional identity and national sovereignty. A comprehensive approach and identifying the core identity was in this decision, the recent decision 2021, in which the Constitutional Court stated that the core identity of the Romanian Constitution is that eternity clause. I explained it, the concept before. Also, the concept of national identity appears in the case law of the Constitutional Court of Romania in other contexts. In decision which ruled that concerning the history and values like elements of the people's identity. Also, we think that when we refer to the constitutional perspective, identity can be viewed here and now in reference with the constitution in force, but also in a historical and evolutionary context. And these two components complement each other, because certain elements of the current constitution of Romania, for example, can be better understood from assessment in a social, historical, political context. And I gave you here examples of our constitutional history, starting with the first constitution, 1866. These are the values which are stable over time. Indivisible state, national unitary indivisible state. Even when the Romania was a monarchy, was a communist state, and even now when is a democracy. So, beyond these permanencies, which are across time or historical present, it seems that there is a wider content of identity which emerges from the case of the Constitutional Court, because I mentioned the identity core, other elements like organization of the judiciary, and so on. Question 8, how has the academic position changed from the accession to the present day as regards to the assessment of the impact of European law? The examination of the Romanian legal literature in this matter does not reveal a significant change regarding the aspect covered by these questions, because in time the authors try to explain, in fact, the legal order of European Union, the effects of the integration, and so on. But what is interesting that is at various times and some intensities and passions, the Constitutional Court of Romania was under the spotlight, and the case law established regarding the interpretation of the application of European law and this relationship with the European Court of Justice was a target of critical assessment. One first moment was the founding of the unconstitutionality of a law transposing of a directive, so-called Big Brother directive, because at that moment Constitutional Court was criticized because confronted with the national law release of European secondary law legislation, the court simply nationalized the European Union source of the national law. These specific criticisms are raised in a general critical context of the attitude that the Constitutional Court qualified as hesitating to address preliminary reference, but after that, finally the Court addressed the preliminary reference to the European Court of Justice and opened the dialogue this way in 2006 with that common case. Substantial debates were determined by the recent decision 390 per 2021. Very strong words in these debates, Roexit, and so on. Also, there was criticism against the decisions of the European Court of Justice. And in this framework, also the topic of national constitutional identity was a key issue. I mentioned it in our presentation, a few of the more relevant interventions in this regard, trying to define the national identity, the constitutional identity, and the competence to give a definition of these terms. So the last question, we tried to analyze it in the workshop, more detailed. So now I'll give just a few words concerning the idea of dialogue in the member state. We found that the constitutional dialogue in different and various forms, preliminary reference, bilateral meetings, international congress of the Constitutional Court, has led or should lead to a higher harmony of the European Constitutional Court. But in this, inspired also by the words before concerning the communication and not dialogue between the courts of the member states, I would emphasize the idea of the communication between the courts, the constitutional judges, and academia, and the importance of this project from this regard. And I gave I mentioned this, I selected from only this conference, 2021 in Latvia, because it was the first time in the history of European Union and judges from the constitutional courts and constitutional jurisdiction of the member states went to discuss the European Union common legal traditions, and as regard the idea of communication, I noticed there this important conclusion, according to which it's necessary to have some help from the academia to define these limits, these words, these values, in order to have a common approach of the constitutional identity at the level of European Union. There are here also links and to other articles or events when the same idea was emphasized, the idea of the cooperation between the judiciary, academia, and even politics to deal with this important issue. And as conclusion, some questions, because we think that the most difficult part of this project will follow, because we have to put together all this research and to find answers to important questions concerning identity. What does it mean, constitutional identity, and who has the legitimacy to define this constitutional identity? Thank you so much for that.